All right, we'll go ahead and get started. We have a lot of fantastic content to cover today. My name is Lisa Rice. I'm the Chief Sales Officer here at Sanderson Firm, and I'll be your moderator for today's webinar. We appreciate everyone taking the time to join us today on the topic of the impact of the Loper decision on Medicare compliance. So I'll go ahead and introduce our speakers today. We have Heather Schwartz Sanderson, who is the CEO of Sanderson Firm. Heather's one of the foremost nationally recognized experts in Medicare secondary payer. She's devoted her entire career uh, into providing simple and straightforward MSP compliance solutions to the industry. Joining Heather is Brendan D'Souza, who is our managing attorney here at Sanderson Firm. Brendan joined Sanderson Firm in 2021 after previously serving as in-house counsel for one of the nation's largest MSP compliance services company. So without further ado, I'll go ahead and turn it over to Heather and Brendan.
Thank you so much, Lisa, and good day to everyone on the webinar today. Thank you for joining today. We issued a blog about this recent United States Supreme Court decision and had a overwhelming response of interest in the topic and even a suggestion that we do a webinar on this topic. So here we are today, and I think it's going to be really, really interesting. As promised in the webinar description, even though Brendan and I are both attorneys and fundamentally we're talking about a Supreme Court decision, we really want to make sure that we're explaining the fundamental impacts of this Supreme Court decision and how it would impact administrative agencies in a simple way. So hopefully you all follow along. Our agenda for today, first, we're going to just kind of lay the groundwork and explain what administrative law is and kind of explain the different branches of government and how this issue came up with the Chevron case initially in 1984. We're going to talk about the original Chevron case, which created the standard for Chevron deference. And then we're going to talk about how it was recently overturned in the Loper decision. We're going to also talk about another seminal case, the Christensen decision. And then we're going to pivot to how does this new Loper decision impact what you are all here to hear about today? Medicare secondary payer compliance potentially, right? We're all kind of making conjectures as to how this might impact Medicare set-asides and Medicare secondary payer compliance in the future. And while we have you all here today, we do want to cover, again, just to make sure everyone's aware, the fact that civil money penalties are coming here shortly for non-compliance with Medicare Section 111 reporting. And we're also going to talk about, just again, as in a briefer again, about the upcoming work comp MSA reporting requirements. So let's dig in. So what is administrative law? Administrative law is a branch of law that regulates the exercise of authority for officials of the government and those agencies executing the law under authority granted by Congress. In other words, it concerns the powers and procedures of government agencies. Arguably, the scope of administrative law is as great as the scope of the government itself. So think about the number of ways in which federal agencies affect everyday life. So some examples of what federal agencies govern, right? They provide subsidies to farmers. They regulate drugs, right? The FDA. They police our borders and airports, right? Think about the TSA. They set workplace safety requirements. Think about OSHA, right? So a lot of different ways they impact our everyday life. But I want to make sure everyone really understands that there are fundamentally three branches of federal government. There's the legislative branch, there's the executive branch, and then there's the judicial branch. So essentially, administrative law and administrative agencies sit under the executive branch of the government, right? They are the means through which the government carries out and enforces law. And under the Administrative Procedures Act of 1946, an agency is any federal government authority other than Congress and the military. The term agency is often used to refer to federal departments, subdepartments, and commissions. So administrative agencies, I want to be clear, they can make actual laws, right? And this would be a law that is actually published with notice and opportunity for comment. So we're going to talk about it later, the Section 111 civil money penalties, right? Those are those penalties up to $1,000 per day per claim that Medicare can levy against non-compliant responsible reporting entities. That came about via an actual law. This was published with a notice of proposed rulemaking, and then it turned into a final rulemaking, and then it was published in the Federal Register. That is actual law. But I want to be clear that that lawmaking process actually creates legal precedent, whereas mere guidance, right, issued by administrative agencies such as reference guides or memoranda or opinion letters are not law. They are not law. They do not hold the weight of law. It is the administrative agency's view or interpretation of the law, which may be questioned as we will cover.
All right, so thank you, Heather. And good afternoon, everyone who is tuning in today. Okay, so continuing on the theme of what administrative law is. So as Heather mentioned, administrative law really permeates just every aspect of our everyday lives, and it's more important than maybe what the general public would think. And one interesting fact that we found after doing some more research into this new Loper decision is, okay, you have these federal agencies who are under the executive branch, and you have Congress who's under the legislative branch. Um, Interesting to know that federal agencies, as it stands today, actually make most of the law, not Congress. So interesting when you consider that, Congress, obviously you have your representatives, you have your senators. These are elected officials, who have been entrusted with writing laws with presumably our best interests at heart. But it's actually these administrative agencies filled with non-elected officials who are actually creating most of the law. We can actually see this through this chart from 1993 to 2016. On average, just looking at these numbers, we see that during really any given year, there's probably about 4,000 final rules and regulations published each year from administrative agencies. So for example, from 2015 to 2016, there were 94,000 final rules. That jumped up in one year to 98,000. In 2009, it went from 72,000 to 76,000. So year over year, it's about a 4,000 increase in the amount of laws that administrative agencies publish each year. So if we go up to the next slide, you ask yourself, okay, how's it possible? How is it possible that administrative agencies are actually creating more laws than Congress? And one of those reasons is just the sheer volume of agencies themselves. There's more than 400 agencies and sub-agencies within the United States. We've only listed about 7 here on this slide. So you have your Department of Agriculture, Department of Commerce, Department of Treasury, Department of Defense, so on and so forth. At the very last one here, bottom right, you see the department which we're all probably most familiar with, is the Department of Health and Human Services, of which the Centers for Medicare and Medicaid Services is a sub-agency within that. So just the number of agencies and just sheer volume, this is how you get just the amount of laws that are created by these agencies each year. So hopping to the next slide. So you see their sheer volume, but okay, what is the legal basis, or what grants these agencies the authority legally to actually craft these rules and regulations? Chief among which, in order from most important or primary importance to least, is the Constitution of the United States. So the Constitution specifically grants Congress the authority to delegate certain rulemaking functions to administrative agencies. So our founding fathers kind of recognized that, hey, we have Congress. Congress is the entity that's charged with drafting laws, but Congress can't do anything, and they need help, and they need help from individuals who are subject matters in their specific fields of law. So the Constitution allows Congress to delegate this rulemaking authority to these agencies, which, as we can see based on the numbers, the agencies definitely take advantage of. Number 2, we have the Administrative Procedure Act of 1946. This one is hugely important. This act obviously, recognizes federal agencies themselves, but probably more importantly, it creates a level of, due process that these agencies have to follow. So if you take a real life example, we're all aware of Medicare's um, uh, final rulemaking on Section 111 reporting and civil money penalties. So if you think back, think back to what didn't happen. You didn't wake up one day last year in October to Medicare saying, "Hey, we've got this final rule. It's in place. It's out of nowhere. It becomes effective as of today. And if you're not in compliance, then tough luck, you're getting fined, X amount of dollars per day per claim. That didn't happen. What did happen was Medicare issued a proposed notice. There was, a proposed rule that Medicare drafted. Medicare allowed a notice and comment period where, stakeholders could create comments and Medicare could respond. There's this whole process in place, and we have the APA Act of 1946 to actually thank for this. Other sources of administrative agencies' power is obviously that particular agency's enabling act. So if we're talking about Medicare, way back when in 1965, President Lyndon B. Johnson signed Medicare into law, right? That created the Medicare program and that gave Medicare its powers. Aside of that, you have federal statutes, which speak to agencies' powers, or you also have common law, which are, you think of traditional law as being, statutes and regulations. Common law is kind of, you can think of it as case law. So sometimes courts have to reference old common law or old case law in determining whether an agency is overstepping its boundaries. So throughout all of this, you'll notice that what administrative law is conceptually, it's just a power struggle. It's a struggle among Congress, the legislative branch, the president, the executive branch, and the federal courts, the judicial branch, to control the entire administrative process. So just keep that in mind as we kind of proceed through. Okay, so why are we here today? Why are we having this presentation? How did we get here? Obviously, we had the Loper decision. Before that, we had the Chevron decision. But what those decisions are about how an agency, how our federal government interprets certain statutes from which that agency derives its authority to act. And there's long been a disagreement both before Chevron and even after Chevron about, who is in the best position to determine or to interpret laws. Is it our federal courts who should do that? Or is that the federal agencies that should be interpreting laws? And those who have been proponents of deferring to agencies, typically their chief argument revolves around agencies having special expertise. So there's tons of different examples of expertise. We've only provided 2 examples here just for the sake of time, but you could have, for example, scientific expertise. So for example, in 1998, the Department of Interior interpreted a statute to allow predictive modeling to determine damage to national resources. So essentially you had the Department of Interior, who is comprised of scientists, conservationists, biologists, and they use predictive modeling to interpreted that the statute allowed them to use predictive modeling for their everyday jobs. And the court said, okay, cool. We, the judiciary, we're not scientists, we're not biologists. We're going to defer to you, the scientists, on how the statute is actually interpreted. You also have policymaking expertise. So for example, in 1991, there was another case, Seventh Circuit Court of Appeals, where the Securities and Exchange Commission interpreted a statute to recategorize trading options on federal government securities put together by a broker, a bank, and a clearing agency. Again, the federal court said, who are we? We're not policymaking experts here. That's not our job. That's not our function. We're going to rely upon the SEC to determine how to categorize, options trading in the world. So that's another example there. And there's plenty more examples of that. So, okay, so we're going to start some case review here. We're going to start with Chevron. So Chevron USA Inc. versus Natural Resources Defense Council Inc. This is a seminal case law when it comes to administrative law, and it's probably the most cited administrative law in American jurisprudence. So if you go to any law school in America, you're learning about this case, first year, 100%. So what was this case about? So way back when in 1977, you had the Clean Air Act. Actually, technically a revision to the Clean Air Act in 1977. And the EPA, Environmental Protection Agency, issued a regulation which interpreted the term stationary source as used in the Clean Air Act. So before this 1977 to that act was made, how that act was interpreted was a state had to be issued a permit if there was a new or modified stationary source within a manufacturing plant. So let's say you have a manufacturing plant as a whole. Within that plant, let's just say you have certain divisions or units. Each of those units under the old term was considered to be a stationary source. So you had a plant and you wanted to add or modify one of those units, you had to get a permit from the EPA. The EPA changed its mind in 1977, and they interpreted the act to effectively say, hey, no longer are these individual units within these manufacturing plants um, stationary sources. Actually, the entire plant as a whole is a stationary source. So what happened was you had these plants that could install or modify pieces of equipment, uh, polluting equipment in their manufacturing plants without a permit. That caused issues with conservationists, and so they filed suit. And so ultimately, the EPA sided with, the court sided with the EPA, but the facts aren't really important. What's the important takeaway from this case is actually the holding itself. And Chevron announced a new standard for reviewing agency decisions involving interpretation of statutes administered by the agency. So what was born out of Chevron was the Chevron deference test. And a court had to ask itself two questions if an agency interpreted a statute one way and it was later challenged by an opposing party. So question number one is, has Congress directly spoken to the precise issue has Congress directly spoken to the precise question at issue? If so, congressional intent wins. So for example, in Chevron, if under that Clean Air Act, Congress wrote in stationary source means XYZ. If it was as clear as day, then there is no, the inquiry stops there, right? And whatever Congress says the law is what the law is. But that didn't happen, so we skipped to step two, or question two. And question two is, if congressional intent is unclear, or if Congress explicitly left a gap for the agency to fill, a federal court must determine whether that agency's interpretation of the statute is reasonable. So obviously a pretty, low bar when it comes to reviewing an agency's interpretation of a law. And that stood the test of time for 40 years until we got to Loper, which I'll let Heather talk about.
Yeah, for sure. So great review of the Chevron standard. I certainly remember learning about it in law school. So when I saw it overturned with the Loper decision, it was quite startling to me. And I'm not going to go too deep into the facts of the Loper Supreme Court decision, which was just issued, what was it, about 2 weeks ago now, Brendan?
Yeah. Mm-hmm.
But essentially it involved a dispute between some New England fisheries and the National Fisheries Service, which is a subsidiary agency of the Department of Commerce. So basically, the Fishery Act required certain fisheries to allow federal observers on board their vessels to collect data for overfishing prevention. And the NMFS interpreted the Fishery Act to also require such fisheries to pay the salaries of these federal observers. So initially in the lower courts, so I just want to take a step back before this reached the Supreme Court. When this lawsuit was brought to light, the federal district and appellate courts initially applied Chevron deference. They basically said, okay, because the administrative agency has said that these vessels should allow these people on board and should pay them a salary to observe their vessels and collect data, we defer to them under Chevron deference. Under the Chevron law, we defer to the administrative interpretation. So initially, the Chevron holding held essentially deferring to the agency's interpretation of the law. But then it did eventually go to the Supreme Court level, and this is the case that we're talking about here. And so whether Chevron should be applied here or not was the issue. So essentially, was this decision of this agency reasonable, and should the courts defer to it? And so ultimately, in this Loper decision, the Supreme Court of the United States declined to apply Chevron, overturned that entire doctrine and said, Chevron has proven to be fundamentally misguided. It has launched and sustained a cottage industry of scholars attempting to decipher its basis and meanings, and members of this court have long questioned its premises. I will say and set the bar that in doing some legal research on this, I found that actually the United States Supreme Court has not applied the Chevron standard since 2016. And we all know that right now, the United States Supreme Court is made up of mostly conservative judges, right? So these decisions, there's been a lot of decisions coming out of the United States Supreme Court, and arguably a lot of this commotion in the Supreme Court is because we've got an election coming right later this year, which could change the dynamics of the bench at the United States Supreme Court, but ultimately conservative decision, right? Because conservatives ultimately favor less government involvement, right? So this decision certainly falls in line with the way that they view the world and view the way that the government should act. So in a 6-3 vote, they overruled the Chevron decision. And now they're saying, so now the new law is that federal courts may not defer to an agency's interpretation of an ambiguous statute. And so Chief Justice John Roberts said, Chevron is overruled. Courts must exercise their independent judgment in deciding whether an agency has exercised its statutory authority properly. Careful attention to the judgment of the executive branch may help inform that inquiry. And when a particular statute delegates authority to an agency consistent with constitutional limits, courts must respect that delegation while ensuring that the agency acts within it. But courts need not, and under the Administrative Procedures Act, defer to an agency interpretation of the law simply because a statute is ambiguous. So essentially what the Supreme Court was saying is that Article 3 of the Constitution held that it is the duty of the courts to determine what the law is, not federal agencies, right? Of course, courts will give due respect to executive branch interpretations of the statutes, but ultimately it's up to the courts to determine whether the law means what the agency says it means. At a high level, the Loper decision reflects the current Supreme Court's formalistic approach to the separation of powers between the branches of government and to statutory interpretation, right? It's a way to kind of keep the administrative agencies in check, right? So going forward, legal scholars have believed now since this decision that regulated parties will now be better positioned to attack federal regulations as exceeding statutory authority across agencies and subject matters. And to the extent that courts will be offering its definitive statute interpretation of statutes, the decision may also constrain agencies from altering regulations when administrations change. So essentially, they're going to be looking elsewhere and not automatically deferring to an agency's interpretation of the law. And Brendan's going to talk about the Christensen case, and then we're going to get to what you're all here to hear about today, which is how does this apply to Medicare secondary payer and Medicare set-asides? But first, let's talk about the Christensen case, Brendan.
Thanks, Heather. And yes, this is the last case we promised. So this case definitely gets a special mention. Christensen v. Harris County is a United States Supreme Court case that occurred in 2000. So really the question is even though Chevron is now overturned, would Chevron deference have applied to CMS's policy-making decisions outlined in CMS's own policy guidance? And the answer to that, based on this case, is arguably not, because the holding of Christensen was the Supreme Court held that informally rendered agency interpretations are not entitled to Chevron deference. So quickly getting into the quick facts of what happened in this case was essentially an agency wrote an opinion letter in response to a regulated party asking whether the statute administered by that agency permitted a particular course of conduct. And what the majority opinion said in Christensen was, quote, interpretations such as those in opinion letters, like interpretations contained in policy statements, agency manuals, and enforcement guidelines, all of which lack the force of law, do not warrant Chevron-style deference. And so when we think about the WCMSA reference guide, which is Medicare's policy guidance on preparation of work comp MSAs, when we think about the NGHP user guide, which is Medicare's policy guidance on how to approach Section 111 reporting, these are arguably policy statements, agency manuals, enforcement guidelines. So arguably under this Christensen case, maybe nothing from a CMS perspective and how CMS interprets law in these guides, maybe nothing actually changed, because according to the Supreme Court, CMS would not have been entitled, or is not entitled, to Chevron-style deference with these two specific pieces of policy guidance.
That's right. So, one thing I want to make clear, now we're going to talk about, how this would apply to MSP, is that what the Loper decision essentially says is that to the extent that a statute or a law is ambiguous, then essentially courts, when tasked with this, with the task of interpreting a law that might be ambiguous, they're not going to automatically defer to an agency's interpretation of that law. So I want to set the stage that, and it is my opinion and as many courts' opinions, that the Medicare Secondary Payer Act is one of the most ambiguous laws that there is out there. We've seen case law. One of the major seminal cases regarding Medicare Advantage plan recovery called the Medicare Secondary Payer Act one of the most completely impenetrable texts within human experience. So based upon this consensus, so we all know, and we're setting the stage now, the MSP Act is without a doubt ambiguous, right? So automatically we know now agencies such as the Centers for Medicare and Medicaid Services will not receive automatic deference going forward as to their interpretation of the MSP within their guides, such as the Work Comp MSA reference guide, such as the NGHP user guide, right? A court now may completely exercise their own independent discretion as to whether that interpretation of the very ambiguous MSP Act was proper or not. So, but remember, before this actually happens, the matter must be brought to a court first, right? It actually must be brought before a court, and Medicare might have to come in and give their opinions on why they issued this guidance and why they viewed the Medicare Secondary Payer Act to render such administrative guidance. We haven't gotten there yet. Again, this is all conjecture as to the future of the Medicare Secondary Payer Act, but we believe, because again, the MSP is definitely ambiguous for sure. Courts have recognized it. So courts in the future are going to exercise their own independent judgment in determining whether CMS interpreted the MSP properly. That we know for sure. That is the ultimate conclusion of this presentation, is that all of CMS's guidance may be questioned in the future by courts because the MSP Act is so ambiguous. So not only the MSP Act, but also the Section 111 laws, arguably a little bit more clear than the MSP Act in and of itself. Probably that one might not be questioned so much, in my opinion. Related regulations that support the MSP Act, such as 42 CFR 411.24. But ultimately, we foresee that CMS's policy guidance might be independently scrutinized by federal courts in the future because it is ambiguous. So as Brendan mentioned, Medicare's non-binding guidance, such as the WCMSA reference guide or the NGHP user guide for Section 111 reporting. I want to specifically talk about Medicare set-asides and how we view that, potentially Section 4.3 of the WCMSA reference guide is more than likely going to be challenged by, a court in the future. So some of you might be aware that in January of 2022, Medicare added a new section 4.3 to the Work Comp MSA reference guide. It went through a couple of iterations. It ended up March of 2022 was the final section 4.3, which caused an industry stir. But essentially, what all of this language here says on the screen, that essentially Medicare reserves the right to fully challenge non-submitted MSAs, even though submitting an MSA to CMS is purely voluntary, and that essentially in their sole discretion, even though parties might have set aside a portion of the settlement to protect Medicare's interests and not submitted it through Medicare's voluntary review process, that Medicare can ignore the whole allocation and deny payment up to the entire settlement amount. And this does not jive with the actual law. And I've said it all along, CMS overstepped their bounds when issuing this. And I'll explain why here on the next slide, and why non-submit MSAs will hold weight in the future. So how does the Loper decision affect MSAs? So first of all, I do want to remind everybody that if you go and look at the Medicare Secondary Payer Act, in and of itself, the word Medicare set aside is not mentioned at all in any Medicare statutes or regulations. It is a creation of the administrative agency of the Centers for Medicare and Medicaid Services, right? So back in 2001, when CMS issued the Patel memo and first introduced Medicare set-asides to the industry as a best practice industry standard, CMS did this because they interpreted the MSP Act to say that essentially post-settlement, workers' compensation settlements with Medicare beneficiaries or reasonably expected Medicare beneficiaries should avoid Medicare being a primary payer in the future. And by doing so, create an MSA so that the Medicare set aside now pays for future medical related to the work comp injury rather than Medicare paying. arguably, I think it's a reasonable interpretation of the MSP Act to, set forth Medicare set-asides, right? Because without Medicare set-asides, Medicare would be paying for injury-related treatment in the future. They would only be a secondary payer pre-settlement, which would not be a proper enforcement of the MSP Act. So I don't think MSAs in and of themselves will be challenged by the federal courts. I think Medicare set-asides in and of themselves, it was a reasonable interpretation of the MSP Act. However, quite possibly a court might disagree in the future. We don't know what the future might hold, but I do think that MSAs are a reasonable interpretation of the MSP Act. However, I do think that certain further interpretations of the laws might be, scrutinized in the future. For example, I talked to you all about just recently Section 4.3 of the reference guide, which was added recently, and Medicare said that they can deny care up to the entire settlement amount and ignore that future medical allocation. Well, they did ignore, we've written about this in many blogs, subsection D2 of 42 CFR 411.46, and it specifically states, if the settlement agreement allocates certain amounts for specific medical services, Medicare does not pay for those services until medical expenses related to the injury or disease equal the amount of the lump sum settlement allocated to future medical expenses. That's a lot of legal jargon. What it essentially means is that Medicare can only deny care for the portion of the settlement that is not allocated for future medical care. This subsection here allows for parties to carve out a specific portion of the settlement for that Medicare beneficiary's future medical, i.e. a future medical allocation, a non-submitted MSA, or a submitted MSA. But to the extent there's a portion of the settlement allocated for future medical, Medicare can only deny coverage up to that future medical MSA amount. They cannot deny care. So let's say the settlement is $100,000 and the parties set aside future medical for that Medicare beneficiary in the amount of $30,000. And it really doesn't matter whether that $30,000 MSA is submitted or not submitted. Let's say later Medicare questions that MSA. Medicare under this regulation can only deny care up to the $30,000 and not up to the $100,000. So what Medicare is saying in their reference guide completely contradicts what's within the law in subsection D2 of 42 CFR 411.46. So I do believe that in the future that section 4.3 will be overruled and will be deemed to be an overstretch of the law. If Medicare wanted to, mandate submission of MSAs to CMS or not allow or not recognize non-submit MSAs, they would need to completely abolish 42 411.462. So essentially, we do believe that in the future that this section of the reference guide will be questioned. And again, the reference guide is not law in the first place, but again, the administrative interpretation of the law is incorrect here in my legal opinion.
Okay, perfect. So thanks, Heather. So Heather's talked about how, the Loper decision could affect, MSAs, but what about Section 111 reporting? And remember, when we're talking about Loper, we're talking about statutes, right? There's got to be a particular statute at issue. And when we're talking about Section 111 reporting, we're talking about Section 111 of the MMSCA. And so when we think about reporting, we can think about reporting at the sake of oversimplifying it is there's, kind of two types of reporting. There's ORM reporting and there's TPOC reporting. When we're talking about ORM reporting, we're talking about a responsible reporting entity reporting whether it has ongoing responsibility for medicals on a claim. So essentially whether they're, accepting coverage or, denying coverage for the claim. When we're talking about TPOC reporting, we're talking about whether the RRE had a settlement, judgment, or other award on the claim. So essentially, whether a settlement has occurred, and if so, how much. So we have RM, we have TPOC. What most, maybe a little bit known fact, but what most probably don't know about Section 111 reporting is when it comes to reporting RM and TPOC, obviously you have to report the ICD or injury codes that are, inherent within the claim. But when it comes to ORM reporting, Medicare has interpreted Section 111 of the MMSCA to mean that if you're an RE reporting ORM, you are permitted to report just the injury or ICD codes related to the claim. So, let's say, I'm an employee, I am, climbing up a ladder, I fall off the ladder, I fall and injure my back, and let's say I'm a Medicare beneficiary. Through ORM reporting, the ICD code that would be reported is my back injury. But let's say that during the pendency of the claim, let's say I just allege some BS charge. Let's say I say, okay, I have this back injury, but I also have some gastrointestinal issues, which are clearly unrelated, but whatever, I allege it under work comp. Under ORM reporting, I would not have to report that GI issue. The carrier would only have to report the back injury. However, CMS has interpreted ICD coding and reporting on TPOC differently. So under TPOC, the RRE or the carrier has to report all claimed, alleged, or released injuries. So using that same example, during ORM, the RRE would have reported the back injury, but now the RRE through TPOC, when it settles, is going to have to report not only the back injury, but the GI or whatever other unrelated issues were claimed by the Medicare beneficiary, which is unfortunate from the carrier's perspective, because the carrier is essentially required to over-report injury information to Medicare. What happens is when Medicare asserts its conditional payment recovery, Medicare sees all these ICD codes and Medicare says, okay, great, we've got all these codes, we made payments for all these injuries, we don't care whether it was related or not non-related, we're just going to wholesale assert a recovery interest for all of these treatments. So the carrier is looking at a huge lien. The only remedy for that carrier is to dispute that through the conditional payment appeals process. So it is possible that, let's say that happens where a carrier is faced with a lien, and a carrier, files suit in federal court saying, hey, look, this is ridiculous. We overreported. We're going to challenge CMS's interpretation of Section 111 such that through TPOC reporting, we should only be responsible for reporting injuries that are related to the claim. So that could happen in the future. That could be one potential effect of LOPR on Section 111 reporting. Okay, so now we're just going to move into just a quick reminder section about what's going on in MSP and just upcoming items. So it's already, July at this point, and we're a couple months away from October. And what happens in October is CMS's Section 111 civil money penalty becomes live. So on October 11th, 2024, that's when we're going to have the applicability of CMPs. And just as a quick reminder for everyone, there's going to be two instances where an RRE can be faced with a civil money penalty. One is untimely reporting of TPOC, or the settlement, and the other is untimely reporting of the acceptance of ongoing responsibility for medical. So RREs have 1 year to report these. If it takes longer than a year, then you're going to face some CMP exposure.
I just realized, Brendan, that today is July 11th, so we're exactly 3 months out from this final rule becoming applicable.
That's which is no time at all. So hopefully everyone's ready.
Yeah.
In terms of CMS's statute of limitations for imposing a CMP for non-compliance, keep in mind there's going to be a 5-year statute of limitations. So, let's say when the rule goes live in October of this year, let's say the rule is live, you have a TPOC, and you wait, let's say 3 years to report that TPOC. From the date of you making that report, CMS has 5 years from that date to issue a CMP. So each year, Medicare is going to randomly pull or audit 1,000 beneficiary records. If let's say you report late and CMS completes that year that you reported and they've audited 1,000 claims and that claim wasn't within the 1,000, guess what? CMS has 4 more years of cycles to pull your claim. So just keep in mind, you escape 1 year, you're not in the clear, CMS could theoretically issue or pursue recovery years after that. Also keep in mind that CMS is not going to just automatically issue a formal CMP against your organization. Thankfully, CMS is going to first start with just an informal written pre-notice. CMS is going to say, hey, look, we noticed that you may have misreported this. RREs are going to be allowed the opportunity to 30 days to respond with mitigating information. And CMS has said, we'll accept any reasonable evidence that you were actually in compliance with Section 111. So that will occur. After that, CMS will issue a formal notice. After the within the formal notice, Medicare is going to specify the amount of the CMP itself, why the CMP was levied, and really next steps for appealing that decision, which would be in the form of administrative law judge hearing. For those out there who may face a CMP in the future, keep in mind that Sanderson Firm will have services that address these CMP issues, so we'll be prepared to help you navigate that when this rule goes live.
For sure. This is a big thing coming up. I do want to also comment regarding the Section 111 penalties that they will be prospective in nature, meaning that Medicare will not issue any penalties for claims and settlements that occur prior to October 11th of this year. But one question that we've received a lot and I want to address, we've had a lot of questions from clients regarding whether they should clean up historical data. Let's say that you have some records that have not been submitted, whether ORM or TPOC pre-October 11th of this year, and whether you should clean that up. And our answer is yes, you should absolutely clean that up. While not cleaning it up might not cause a civil money penalty, it could cause more conditional payment issues, right? Because you want Medicare statute of limitations to start running, and the only way to do that is by submitting a TPOC record. So to the extent that you have some open ends that you need to tie up with regard to your historical claims, we absolutely recommend that for conditional payment exposure, even though it wouldn't cause a civil money penalty. We do offer guidance on Section 111 reporting, and actually do reporting ourselves. We are a reporting agent to CMS. We also do audits as well. So if you have any questions about that, please feel free to follow up. I do want to talk about another upcoming MSP development that's big, other than the Section 111 CMPs, is now we're going to have to be reporting work comp MSA information through the Section 111 reporting come April 4th, 2025. So responsible reporting entities are now going to have to populate several data fields relative to MSAs. I want to be clear, this only pertains to workers' compensation claims. This does not pertain to liability and no-fault claims. And it seemed kind of curious why out of nowhere this came, right? Because MSAs became a de facto part of work comp settlements with Medicare beneficiaries in 2001. The MMSEA Section 111 law was passed in 2007 and implemented in 2010. And now here we're going to be in 2025 syncing up the two. Medicare is looking to sync up the data. And so there was a lot of questions. Why all of a sudden does CMS want MSAs reported? And they held a webinar, which was very helpful to the industry to kind of glean why Medicare was looking to have this MSA information reported via the Section 111 data, particularly if the MSA had already been submitted to CMS for review under their voluntary process. And CMS representatives commented that a lot of times, even when they review an MSA post-settlement, they don't necessarily receive a copy of the settlement document, so they don't know that the MSA was funded. Essentially, they want to know the MSA information, whether it's a submitted MSA, a non-submit MSA, or otherwise, because they want to be able to properly coordinate benefits in the future and make sure they're not paying for injury-related care that should otherwise be covered by an MSA. So this makes sense. So submission of the data, again, it's regardless of whether this is a submitted MSA or a non-submit MSA. This is not an attack on non-submit MSAs. This is just so that Medicare has greater visibility into Medicare set-asides. Data needs to be submitted for all work comp TPOC, so all of your work comp settlements, regardless of the value. Does this suggest heightened scrutiny for workers' compensation settlements when nothing is set aside for the Medicare beneficiaries' future medicals? I think so. What do you think about that, Brendan?
Yeah, I mean, I agree. I don't know that I have anything to add, but I completely agree.
Yeah, I mean, I think like to the extent that a responsible reporting entity is consistently reporting TPOCs with Medicare beneficiaries and the MSA amount is always zero, I think it's going to raise some alarm flags. I mean, Medicare has said that to the extent there is a zero populated in the MSA field, they're not necessarily going to argue with it, and they're going to assume it's a denied case, right? Or no future medical care is required. But it could be questioned in the future. And this is really something to think about with your MSA practices. If you work with workers' compensation claims with Medicare beneficiaries, thinking about how Medicare is now going to have the insight into Medicare set-aside data, and they're going to be looking at it, right? There are all these new fields that need to be added to Section 111 reporting systems, right? Medicare wants to know the MSA amount, the MSA period, if it was funded via a lump sum or an annuity. And if it's an annuity, a structured MSA, they want to know the initial deposit amount, the anniversary of each year, how much money is going to be deposited. If it was a submitted MSA, what is the case control number? And if the MSA has a professional administrator, what their EIN is. These will become required fields, and they'll be made part of the TPOC, that is going to be submitted via Section 11 reporting. So a couple of points to keep in mind. All non-group health plan responsible reporting entities are required to report this information for all work comp settlements involving Medicare beneficiaries, regardless of the total settlement amount and regardless of whether the MSA was voluntarily submitted or whether it was a non-submit MSA. And submission of an MSA to CMS for review, even if the threshold is met, again, we've talked about this earlier, submission of an MSA to CMS is voluntary. And, we should really be thinking about that. Even in Medicare's reference guide, they reference the fact that if future medical is warranted, even if the settlement falls below these voluntary review thresholds, that an allocation or a non-submit MSA should be provided, right? These thresholds, these voluntary thresholds, are simply workload thresholds. They are not safe harbors to Medicare compliance. And so really think about how you're handling Medicare set-asides and making sure that we are populating these fields. Something really important to keep in mind is that in the event that these fields are not populated, that Medicare can return a hard error on your Section 111 file. So what this means, let me backtrack a second. We've had the question, if you don't populate these MSA fields, would it cause a civil money penalty of up to $1,000 per day per claim with inflation? And the answer is yes, not directly, but here's why. If you don't populate the MSA fields, causes Medicare to return a hard error, which means CMS has rejected the file, which is like it was never reported in the first place. And now you have a situation where you would have an untimely TPOC or an untimely settlement report. So essentially, you would be potentially subject to these CMPs for failure to populate MSA information. So it's really important, just like timely reporting your TPOCs and timely reporting your ORM acceptance, you definitely want to make sure that you are populating these MSA fields, because if you don't, you're going to get a hard error and you could get a penalty. Brendan, why don't you tell everybody here today that might be interested about our Medicare secondary payer accreditation?
Sure. So MSPA, or the Medicare Secondary Payer Accreditation, is one of our pride and joys here at Sanderson Firm. So Sanderson Firm, in coordination with Work Comp College, has developed a course that teaches any interested party of all knowledge levels of MSP about Medicare secondary payer compliance. So there's currently 9 modules or 9 courses, which are fully on demand, fully online. Students can enroll and proceed through the course at their own pace. It covers what MSP is, what Medicare set-asides are, Section 11 reporting, Medicare conditional payments. It has a case law section in there, kind of similar to the sort of case law presentation that we gave today. Just a full knowledge of MSP information. We have people who have signed up for the course who are just entering the MSP space and literally don't know anything about MSP. Probably couldn't tell you what the difference between Medicare and Medicaid, and the course has been great for them. We have people who are maybe more middle level, who maybe only, in terms of knowledge base, who maybe only handle one aspect of MSP. So we've had nurses, for example, who, their primary job function is, of course, writing MSA reports. Those nurses have taken the course and they've learned a lot about Section 11 reporting, conditional payments, even more about the MSA drafting process overall, all the way up to people who simply just want to kind of brush up on their knowledge of MSP. So it's been a great educational tool in the industry that we're super proud of. We've had this course has only been around since February of this year. We've had, I think, over 65, 70 graduates at this point. So it's blowing up. We're super proud about it. And for those who want more information, feel free to visit workcompcollege.com. And there's a link there with a little video, a link to register for the course, and more description about kind of MSPA overall.
And this is just a listing of the services. So, Sanderson Firm solely focuses on all things Medicare secondary payer. Heather mentioned earlier, we provide Section 111 mandatory insurer reporting as well as audits. We also offer an array of Medicare set-asides depending on what your needs are, from a traditional MSA, liability MSAs, indemnified MSAs, legal compromise. We also provide medical cost projection as well as medical mitigation services and pre-MSAs. We also work to identify and dispute Medicare conditional payments, as well as Medicare Advantage plans and Part D plans, as well as healthcare liens that you may have, and Medicaid liens. We also offer MSP legal advice, settlement agreement review, MSP opinion letters, and best practice improvements.
Great. Well, we're going to give everybody 3 minutes back of your day. Again, thank you so much for attending today. We hope it was informative. If you come up with any questions post-webinar, we're here for you. We'd love to be a resource to you. And stay tuned for more MSP updates and more webinars to come this year via our blog. If you're not subscribed already, please do subscribe. And wishing everyone a great day. And thanks again for attending.